A major legal battle over the National Firearms Act and its rules about short-barreled shotguns has reached the Supreme Court, and the Trump administration just filed a really interesting response. Let's dig into what's happening with this case. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. Alright, let's dive into the details. Like I said at the beginning, we're covering a really important challenge to the National Firearms Act that's currently before the Supreme Court. The case is called U.S. v. Rush, and it's challenging the NFA's restrictions on short-barreled shotguns. This challenge is asking the Supreme Court to rule that the NFA's restrictions on these firearms violate the Second Amendment. The petition also highlights how the Supreme Court needs to step in and fix all the confusion and defiance happening in lower courts about what kinds of weapons are actually protected by the Second Amendment. Initially, the Trump administration sent a notice to the Supreme Court saying they were waiving their response to the petition and wouldn't respond to this NFA case unless the court ordered them to. Well, the Supreme Court did order them to file a response, and the Trump Department of Justice just submitted it. In their response, the Trump administration argues that the Supreme Court should deny review of this case because they believe the NFA has at least some situations where it can be applied in a constitutional way. And therefore this case should survive what's called a facial challenge. That's some legal terminology, but it's one of their main arguments. But here's where it gets really interesting. They also argue in this brief that the underlying question of whether short-barreled shotguns are arms protected by the Second Amendment is something that should be answered in a different case, not this one. The Trump DOJ is actually calling for the Supreme Court to take up a state AR-15 ban or rifle ban case to address this topic instead of dealing with the more complicated and messy issues surrounding short-barreled rifles. The Trump DOJ argues that a state rifle ban case would be a better way to answer the question about what types of arms the Second Amendment protects. They say once the Supreme Court does that, it will give clearer guidance to other courts on how to handle this short-barreled shotgun question. For those who don't know the background, this NFA short-barreled rifle case involves Mr. Rush being caught with an unregistered short-barreled shotgun. The case started in February of 2022 when a police officer saw Mr. Rush, whose driver's license had been revoked, pull into a driveway with his truck and then walk to a courthouse for an appearance. After leaving the courthouse, Mr. Rush walked across the street to a nearby apartment complex and went inside a house. About an hour later, Mr. Rush's sister left the apartment, got into the truck, and drove away. The police officer followed the truck and pulled it over. He talked to the sister who was driving and asked her to call Mr. Rush and have him come to the vehicle. While this was happening, the police officer looked into the vehicle and saw what he thought was marijuana in the center console. Because of that discovery, the police officer searched the rest of the vehicle, and Mr. Rush arrived right when this was going on. As Mr. Rush got to the truck, he opened what I believe was the back truck door and reached to grab an object on the floorboard. After a brief struggle with the police officer, Mr. Rush was arrested. They found a loaded short-barreled rifle on the floorboard of that truck. Mr. Rush later admitted that he had intended to grab the rifle and run away with it. Because of this whole situation, Mr. Rush was charged with possessing an illegal short-barreled shotgun in violation of the NFA. On review, the district court denied his motion, deciding that short-barreled rifles are dangerous and unusual firearms and therefore not protected under the Second Amendment. This decision was then appealed to the Seventh Circuit, who on review affirmed the district court's decision by relying on the Supreme Court's earlier ruling in the case U.S. v. Miller. The Seventh Circuit found that Miller remains controlling precedent and that the NFA's restrictions are consistent with the historical firearms regulations mentioned in Bruin. In response to all of this, Mr. Rush has now filed his petition to the Supreme Court. Mr. Rush is also supported by the NRA, and the NRA in this petition on behalf of Mr. Rush argues that since the Supreme Court issued Bruin, Courts across the country have struggled to answer the many questions resulting from the court's new analytical framework. In particular, the debate about what constitutes a bearable arm covered by the Second Amendment has gained new relevance. They argue that this case presents several issues that are dividing lower courts and is a suitable case for the court to clarify what arms the Second Amendment actually protects. Like I mentioned earlier, the Trump DOJ originally waived the right to respond to the petition, but the Supreme Court then ordered the Trump DOJ to file a response. Well, the Trump administration recently just filed the response, and they first argued that the petition here should be denied because the NFA is facially constitutional. They argue that there are some valid applications of the NFA to a point where it doesn't fully violate the Second Amendment, and based on that it should survive a facial challenge. That's some legal nuance revolving around what the Supreme Court has said about facial challenges. But more importantly here for this case is what the Trump administration argues regarding these types of arms bans and what they want the Supreme Court to do about clarifying what arms are protected. The Trump DOJ argues that this case is not the proper vehicle for reviewing and essentially deciding what arms are protected under the Second Amendment. They argue instead that the Supreme Court should take up a state rifle ban case to answer that very question. The Trump administration states in the brief that Mr. Rush instead asked this court to grant certiorari to resolve a variety of other analytical issues, such as the meaning of the word arms in the Second Amendment. Some of the questions that petitioner raises may well warrant review in appropriate case, but this case would be a poor vehicle for addressing those issues. Other types of cases, for instance, they state cases involving state laws banning AR-15 rifles would provide better vehicles for clarifying the appropriate framework for discerning what types of arms the Second Amendment protects. Based on that reasoning, the Trump DOJ in the response asked for the Supreme Court to deny review to this case and potentially instead grant review to a different challenge like an AR-15 rifle ban case. If that's the case, it would be also interesting to see if the United States government and the Trump administration decides to file an amicus brief in a different case that's currently pending and seeking Supreme Court review like the Veramontes versus Cook County rifle ban case that we've talked about here on the channel. That case is currently pending in front of the Supreme Court and seeking Supreme Court review. And we've seen that the Trump DOJ already in the past has done something similar in supporting one of these rifle ban cases, like the ones in the Seventh Circuit dealing with pica. And even in that challenge in the Seventh Circuit, the Trump administration and Harmony Dillon actually joined in those oral arguments to argue against the state of Illinois' bans on rifles and magazines. So again, a very important challenge that's now moving forward in the Supreme Court. The Trump administration filed the response arguing that the petition should be denied, but then they also argue that the Supreme Court needs to take review and address these other questions revolving around arms in something like a state AR-15 rifle ban case. So this is very interesting, and we're going to see how this develops and how this moves forward. As we get more information, I will let you guys know. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.